Hey up there, legal warriors. In this video, I'm going to cover the three main methods of getting a domestic violence case dismissed in Washington state. Are you interested in that area of the law? If so, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get to see it. More people will get the help they need. Now, as always, I'm just going to jump right into it. Let's start with what I mean by a domestic violence crime. In Washington state, domestic violence itself doesn't actually define a crime. It defines a relationship between the parties in a crime, the suspect and the victim. So if the suspect and victim are family or household members, that could be people that have lived together, people that are related by blood or marriage, people that have dated, that have formally dated, spouses. It's a pretty broad definition. But if that relationship exists between the parties, then many crimes are designated crimes of domestic violence. The one we might think about most commonly is assault in the fourth degree domestic violence. So boyfriend, girlfriend, brother, sister, roommate, father, son, etc. Any type of assault between those people, it's designated a domestic violence charge. And as we probably all know, those are taken much more seriously in the system than crimes that are not designated domestic violence. Other types of domestic violence crimes, malicious mischief. It's a lot to say, but it basically means property damage. Could be trespass, even theft, domestic violence, harassment, making threats, stuff like that. So if you're charged with domestic violence, and you're trying to get that case dismissed so it doesn't appear on your record, and so we stay out of jail, and so maybe we keep our firearm rights, all these things, then there's going to be three primary methods that I see and that I think the entire defense bar uses to try to get domestic violence cases dismissed. And I think the first method that most of us use is some form of negotiation. And negotiation doesn't mean negotiating with the alleged victim. They're not a party to the case. The alleged victim, believe it or not, is just a witness. The party to the case is the defendant, that's you if you're charged with the crime, and then the government as represented by a prosecuting attorney. It could be a county prosecuting someone, it could be a city, but there'll be someone representing the government, and your defense attorney will oftentimes try to negotiate with the prosecuting attorney to come up with a certain result. And if you've been a viewer of this channel for a while, you might guess what some of those negotiating factors might be, but let's just go down the factors that your attorney might use one by one. I think the first thing that the attorney will use, and many people think about this, so it may not be the primary thing, is looking at the police report and looking at the 911 call and finding out what the strengths and weaknesses of the prosecutor's case is versus what your version is, right? What did the police see? What did the police write? Were there any injuries? Was there any broken property? Who are the witnesses? Is it just the defendant and the alleged victim? Are they the only witnesses? Are there any aggravating factors? Things like that. Now, again, the fact pattern, believe it or not, is not the end-all, be-all in the negotiating phase of the case because the prosecutor has hundreds and hundreds of cases they have to deal with. They're not going to fine-tooth every little detail in the report and try to see it your way. Hopefully, your attorney approaches it from a broad perspective. Hey, here's some of the weaknesses. Here's some of our version. Here's why maybe we should try to work out a resolution in this case, either because prosecutor, you might lose the trial, or do you really want to go through, a week-long trial for this particular fact pattern? So number one in negotiation is you look at what the allegations are and what the strengths or weaknesses at a general level are of those allegations. The second thing, and I think this is more important from my perspective, is the actions of the defendant can influence, after the charge, the actions of the defendant can influence the prosecutor's willingness to be willing to resolve the case without a criminal conviction, to get some type of dismissal in the case. And why does that make sense? And what do I mean by actions? Well, by actions, I usually mean some type of classes. For domestic violence charge, it might be DV, MRT, domestic violence moral recognition therapy. Basically, 6 months of classes once a week, very inexpensive, sort of the gold standard now in Washington State, because it's an objective type of class versus subjective type of classes. Subjective classes, in my opinion, are what you might end up doing from if you're forced to do a state-certified domestic violence batterers treatment evaluation. In my opinion, those are almost always come out the same way. 52 weeks of weekly treatment. You have to go in and say certain things, or they'll be found not in compliance because you're not accepting responsibility, even though maybe you're not guilty of anything. So, but classes, if you're taking some proactive action, now the prosecutor can feel that they're part of the solution, right? If we don't do anything as the defendant to show that we're going to improve ourselves from the allegations, even if we're innocent, you only really give the prosecutor one option to respond to the case, and that's, with the conviction, because prosecutors' jobs are not to let us go. Prosecutors' jobs, in my opinion, are to respond to the case in some way. So if we've done something to better ourselves and to show that there's something going on, now the prosecutor can at least, truly feel they have been part of something, and now they're more willing to hear, the factual debate about, what happened, which I talked about in step 1. Now, some pointers: you don't want to just go jump into some class you find on your own. You don't want to trust the internet about telling you what to do, because prosecution and courts are very local, right? Each place has a culture. One court will accept one thing, one prosecutor will accept another thing. We're going to have a different approach in a Bellevue case than we are in a Bothell case than we are in a state case, not because they're different laws, it's because each of those prosecutors have different ways of doing things. And if we're having our client do affirmative steps, we want to make sure that that trouble, time, and expense gets the maximum benefit for the case. So talk to your attorney about what you should do. Don't just go do it on your own unless you're understanding that you may not be doing something that's going to help your case as much as doing something else can. So as far as negotiation, that's step 2. What you do is really important. The third step in negotiation, I think, is time. Some time needs to pass so everybody can feel more comfortable about the situation. As you might guess, when a prosecutor or a court sees a report for the first time, that's when usually the most shocked by it, right? It's new. We know something shocking. The first time we see it is the most shocking. When we see it a few more times, we're sort of used to seeing it. Also, the system is sort of backed up, and so prosecutors and courts aren't so used to seeing cases negotiated very early, right? Sometimes a prosecutor can feel really annoyed if you reach out to them too early about a case. Not all prosecutors, but some of them, because they're so buried with the old cases, and the system is just, sort of getting by in most places. So as time passes, then usually there's going to be a better negotiation point. So as far as what we might negotiate for, well, something that isn't a dismissal, given what this video is about. Could be a straight dismissal, prosecutor moves to dismiss. Oftentimes a stipulated order of continuance. It's a contract between the government and the defendant that ends typically in a dismissal if we do certain things. We have some videos on this website about this channel about stipulated order of continuance. And so that's the main way we can safely get a case dismissed, because if the prosecutor ends up giving you an offer that ends in a dismissal, there's no risk that you don't control. Okay, so let's move on to number 2. What's the second method of getting many DV cases dismissed? Well, it's a riskier method, but it's a more aggressive method, and some people prefer that. That's just go to trial, right? Go to trial. Prove the case, prosecutor. You don't have proof. There's not enough evidence. Those types of things. At a trial, the defendant gets to choose if they testify or not. The government has to bring in their witnesses, bring in the police officer. Usually they'll need to bring in the victim, not always. When I was a prosecutor, I have convicted someone of domestic violence without the victim appearing, because there's hearsay exceptions, stuff like that. But you'll want to talk to your attorney. Usually you end up going to a trial if you have a very unreasonable prosecutor, their case is so weak, or you might have to due to other collateral issues. You're on probation somewhere. Your immigration attorney might advise you need to go to a trial, those type of things. That's number 2. And then number 3 sort of relates to number 2. The third method of getting a case dismissed is the victim is not interested. For the most part, most domestic violence cases are going to require the victim to show up and testify. Not all of them. You need to talk to your attorney. There's excited utterances, present sense impression, exceptions, a lot of words as a lawyer, to the hearsay rules. But you'll need to talk to your lawyer about that. But for the most part, if the victim is not going to participate and not going to cooperate, the prosecutor may be forced to dismiss the case even prior to a trial. There are some jurisdictions that will dismiss prior to a trial if they cannot get a hold of their alleged victim. And so that's a lot of strategy involved. You can't tell alleged victims not to show up. That's witness tampering. Do not do that. You don't want to get charged with that type of felony, right? But the three most common ways, again, 1, negotiation. That one works a lot. 2, trial. Let's hope you happen to get there. And 3, victim isn't cooperative and the prosecutor has some sense and realizes, well, hey, if I don't have a victim, I can't proceed. And if they don't want to pursue it, maybe I don't want to pursue it. And how will a prosecutor make that decision? Well, personal preference, a bad record, right? That case I took to trial as a prosecutor with no victim. The suspect in that case probably had like 6 or 7 dismissed DV cases. And as a prosecutor, I wasn't going to stand for that anymore. And so we took care of our job. But those are the things that I want you to think about for the primary methods of getting a domestic violence case dismissed in Washington State. There's a few others. There's deferred prosecution that exists for domestic violence. Ask your attorney about that. It's basically doing a treatment program. Takes quite a few years, but that can end in a dismissal as well. And there's a few more I haven't covered, but those are the ones I want you to know about today. So if you found this useful, please like and please subscribe. More people get the help they need. And more importantly, if you have a domestic violence case in Washington State, feel free to reach out to my firm. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.